The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our next case is Cunningham versus the Goodyear Tire and Rubber Company et al. We will hear from the appellant.
Good morning. May it please the court. My name is Angela Craddock of Youngmore and Henderson for the defense.
Let me interrupt. I should have said this. Sorry, Ms. Vanderberg. Thank you. Justice Berger is recused in this case. I apologize for the interruption. Thank you.
Thank you. We're here on behalf of the defendant's appellants, Goodyear Tire Rubber and Liberty Mutual. I'd like to reserve 5 minutes for rebuttal, please. This appeal is here based on Judge Tyson's dissenting opinion in the Court of Appeals, arguing that the majority wrongly applied de novo review to the Industrial Commission's findings of fact determining the last payment of medical compensation under GS 97-24 so that it could reweigh the evidence and cause a different outcome. The dispositive factual question to determine the last payment of medical compensation required the commission to weigh conflicting lay witness and expert evidence as to the medical reason for plaintiff seeking care at her employer's on-site clinic on April 25th, 2017. That is ultimately a question of medical causation, and we therefore agree with Judge Tyson's assessment that the Court of Appeals erred in applying de novo review to it.
Ms. Craddock, I'm sorry to interrupt you. I'm having a little trouble hearing your audio is a little echoey. But I didn't hear what you said about the question, that something was a question of medical evidence.
Medical causation. Can you hear me if I speak louder?
I can hear you fine. It's just, it's sort of garbly. It's loud enough. It's just not clear enough.
May it please the court, I have no objection to suspending the time while we're sorting this out.
Thank you.
Which looks like Mr. Wood may already have done.
Is anybody else hearing that, or is it just on my end?
Is this better?
Yes.
Okay.
Much better. Thank you. Sorry for the interruption.
So that is ultimately a question of medical causation. And we therefore agree with Judge Tyson's assessment that the Court of Appeals erred in applying de novo review to those findings. Had it applied the proper standard of appellate review afforded to factual determinations concerning the rights of the parties under the Act, as Judge Tyson correctly adduced, it should have determined that competent evidence supported the Commission's findings of fact and that those findings justified its conclusions of law, such that the full Commission should have been affirmed. The Court of Appeals justified its de novo review of the facts in order to reverse the Commission's dispositive factual finding based on an assertion that these facts are jurisdictional. We submit that the errors in the Court of Appeals' cursory reasoning for that designation is a good illustration of what Justice Cardozo described in a different context as the tyranny of labels, meaning the tendency to extend a general rule to a new situation without regard for the underlying reason for the rule. And that can lead to distortions of the law. So we contend what happened with the selection of the standard of review here, which is made clear through examination of these 3 points. The reasons supporting jurisdictional fact doctrine do not apply to examination of the condition precedent imposed on a plaintiff by 9724 to timely file a claim. It's consistent with this court's historical treatment of questions arising under 97-24 and the standard of review applied. And the facts of this case show how impractical it would be and workable it would be for the appellate court to intervene on factual disputes, which must be resolved under 97-24 when they overlap with the factual determinations that are to be in the purview of the Commission. So to look at those in turn, we know that the ordinary standard of reviewing the Commission's factual findings is to determine no more than whether they are supported by any competent evidence. And that is, that comes from the Act itself. 97-91 provides that the commission is to decide all questions under the Act. And this court has construed that to mean questions determining the rights asserted by injured workers under the Act. Also, 97-86 provides an automatic right of appeal to the Court of Appeals, but says a final opinion and award of the commission is conclusive and binding as to all questions of fact. But the commission can't hear and adjudicate those questions for just anybody claiming to be a party who asks them to decide them. Only those who are subject to the Act based on the nature of their employment relationship as defined by the Act. The Act relates the rights and liabilities of employee and employer by reason of injury and disabilities arising out of and in the court of the employment relation. Where that relation does not exist, the Act does not apply and has no authority to apply the Act to persons falling outside of its scope, no matter what they've done or no matter what has happened to them. Their remedies are at common law. So in Aycock versus Cooper, this was in 1932, this court announced a different standard of review for what it deemed to be jurisdictional findings of fact. Those that concerned whether a person is within the scope of the Act, if it could ever apply to them. In that case, it dealt with, whether the employer regularly employed 5 employees, which was the standard in the statute at that time. And when the court said that, well, they need to do de novo review on those findings, was because a contrary holding might present a serious question as to the validity of the statutory provision with respect to the effect of the finding of fact made by the commission. In other words, we don't regard as conclusive findings of fact that must objectively exist to authorize the commission's exercise of statutory authority in order to prevent the agency from expanding the scope of its power to people who fall outside of its scope, beyond its statutory grant. Enlarged review of those factual findings can take place without doing violence to the Act's directive that the commission is to decide questions arising under the Act with respect to the rights between the parties, because they involve completely separate evidence. Different evidence determines the nature of the employment relationship, whether an injury by accident has occurred, whether causation is established, whether or not disability is established. So just as in Aycock, this court has extended that rule, reasonably so and workably so, to other questions on what the nature of an employment relationship is, on which the commission's jurisdiction rests, to questions of whether the plaintiff is an employee versus an independent contractor, and in cases where an injury happens outside the state, if there are features to that employment relationship that bring it within a long-arm statute under 97-36. The qualifying or disqualifying nature of the employment relationship is what exists regardless of the facts of the claim. So in Hart versus Thomasville Motors, this is a case in the 50s, dealing with an employee or independent contractor issue. This court again made a distinction between jurisdictional questions and those dealing with the rights of the parties or rights to avail themselves. Jurisdiction does not relate to the rights of the parties as between each other, but to the power of the court to hear and adjudicate. The question of its existence precedes the question of the right of the parties to avail themselves of its jurisdiction if it exists. So facts on which the commission's authority to hear and adjudicate are jurisdictional and appropriately get a de novo review. Facts on which a party's right to avail herself of the commission's jurisdiction involve a determination of the rights asserted by an injured worker, fall under 97-91. Those findings are conclusive if supported by any competent evidence. In this case, 97-24 does not concern the commission's authority to hear and adjudicate. That was established by stipulations of the parties. Goodyear employs more than 3 employees. Plaintiff was in an employee-employer relationship with Goodyear. The issue is whether she took action required of her by the statute to avail herself of the commission's jurisdiction. And for that, the statute the standard of review applied should be just the ordinary standard. Was there any competent evidence to support the commission's findings? But what the Court of Appeals did in this case was it just took, we talk about availing yourself to the jurisdiction. It's a condition precedent to availing yourself to jurisdiction under 97-24. Use that word jurisdiction, looks at the jurisdictional review and thinks that it applies, but really it doesn't when you look at the underlying reason for the rule. And that is consistent with this court's application of the standard of review in cases looking at 97-24, going back to the beginning. There's 1937 in Winslow versus the Carolina Conference of Seventh-day Adventists that this court introduced the idea that 97-24 is a condition precedent and versus a statute of limitations, and therefore it was deemed jurisdictional for purposes of asserting an estoppel defense, meaning you can't, if it's a condition precedent, you can't assert estoppel, and if it was statute of limitations, then you could. That was the holding at the time, and even at that time, when the court completely bought the idea that it's jurisdictional for purposes of estoppel, it still, in that case, applied the standard of review that is ordinary to the commission's findings of fact. It said that the commission's findings that the proceeding was not begun and that the claim of the plaintiff was not filed until after the expiration of the 1 year from the date of accident, that those findings are final and conclusive, that the judge reviewing the intermediate review from the Superior Court judge was without power to modify, change, or strike out those findings. And it was error for the intermediate reviewing court to change them. So in no case since then has the court deviated from that standard of review for 97-24, despite the fact there's been sort of a shifting point of view of the extent to which its characterization as a condition precedent impacts whether estoppel as a defense can be asserted. In this last case where this court reviewed 97-24, which was Gore versus Myrtle Muller, it changed its mind about estoppel and kind of disregarded the designation of a condition precedent as jurisdictional for estoppel purposes. And another thing it did was the Court of Appeals in Gore had applied this jurisdictional de novo review of the facts, and the Supreme Court changed that and applied the ordinary review just as it has, dating all the way back. So, why it doesn't work here, the question of the last payment of medical compensation in this case really brings into focus why it doesn't work, because it really was a question that called for a determination of medical causation. The Court of Appeals majority said as much. It said, though not explicitly stated in 97-24, medical compensation must be related to the work injury when you're looking at the last payment of when the last payment of medical compensation was made. And then it overturned the commission's factual determinations that were based on the commission's weighing of evidence presented by Nurse Avant and Frank Murray as more persuasive than the plaintiff's testimony.
Ms. Craddock, I just want to make sure that I understand what you're asking us to hold with regard to whether or not filing within the 2-year period is jurisdictional or not. And it's not clear to me whether you're saying that that Gore essentially. So I start with Dowdy versus Fieldcrest Mills, where our court said that the plaintiff is required to establish in order to confer jurisdiction on the industrial commission. The plaintiff has to establish they filed within 2 years. So in Dowdy, our court said this is jurisdictional. You have to prove it for the industrial commission to have jurisdiction. And I understand your analysis about Gore. But are you saying that Gore essentially silently overturned Dowdy and it is no longer a jurisdictional question? Or are you saying that it's jurisdictional, but there are some jurisdictional facts that we should apply any competent evidence standard to, while other jurisdictional facts we reviewed de novo?
So Dowdy does deal with a different statute, but it is similar. There are different facts that need to be found. And Dowdy was before Gore. When Gore expressly said, you know, a condition precedent is different and distinct from subject matter jurisdiction. And I think I would endorse the argument that Gore kind of tacitly overruled that older reasoning from Dowdy, because Dowdy made that, said that without analysis, just as the Court of Appeals did here, as to why it would be important that the statute be avoided, that they do de novo review, because otherwise the commission could be applying the act to somebody who completely falls out of its purview. But we know that these parties could fall within the purview of the act if the plaintiff timely files a claim.
Right. So if we are, and just to make sure I'm clear, if we are to agree with you that it is not a jurisdictional question whether or not the plaintiff has filed within the 2-year period, there's also kind of a pretty substantial list of Court of Appeals opinions that we are also overruling, because that held that so Caps versus Southeast Cable, Morales Rodriguez versus Carolina Quality Exteriors, that those are 2011 and 2010 decisions from the Court of Appeals. It's been quite regularly decided by the Court of Appeals that filing within 2 years is jurisdictional.
Your Honor, if I'm not mistaken, Caps and Morales did not deal with 9724. Those cases dealt with employer-employee questions. There was at least one case where the Court of Appeals did apply at 9724, or stated so in 97-24, and that was the Erickson versus Siegler case. But in that case, it dealt with, you know, out-of-state medical treatment, if that counted as a payment of medical treatment, and that was really not an application to the facts as it was done in this case, to overturn credibility determinations about medical causation. So even if the court doesn't agree with our assessment that really it shouldn't apply, jurisdictional review shouldn't apply at all to findings under 97-24, but I don't think it does because of the points that we've made about the differing nature. It certainly shouldn't to questions of medical causation, and there's no other case where the court has done that, because that overlaps with what the court has to, with what the commission has to decide. So take this case.
I may have gotten lost in the weeds, Ms. Craddock, and if I did, I apologize. But at a minimum, to accept your argument, don't we have to find that Gore overruled Dowdy in the Court of Appeals, the Court of Appeals case that you mentioned?
Well, Dowdy has a different, it deals with a different statute than Gore.
But you did. I understood you to agree that the statute that was at issue in Dowdy is certainly similar to the statute that's at issue here.
I don't think that you have to address Dowdy specifically with your holding in this case, addressing 97-24.
But in order, but your argument, if we were to not overrule Dowdy, we would have to say in effect that two similar statutes get treated differently.
They deal with different questions about information flowing to the plaintiff versus actions taken by the plaintiff. So it doesn't work here because in this case, you know, the question, the Court of Appeals said, okay, we're gonna decide that she really went to the doctor on April 25th, 2017 because of her 2014 back injury. But then in a footnote 5, which I think we had a typo in our brief and said 3, it's footnote 5 of the Court of Appeals opinion. It said, but we're not deciding just because we say there's jurisdiction, whether she proved an injury by accident or whether she proved causation. Those are questions that she has a burden of proving it and the commission has to decide that. So you have a lot of complications when it goes back down to the commission. You've already had the Court of Appeals kind of like undermine their reasoning on the findings, but it's not really a law of the case issue because the court says they weren't holding it, but that's certainly complicating and underscores how it is stepping on the duty and prerogative of the commission to make findings of fact, to make the legal determinations of whether injury by accident have been proven or medical causation have been proven. So I think that is a problem in this case that is elucidated, notwithstanding issues in Dowdy, that shows the problem with application in regards to 97-24.
Well, if jurisdiction is legitimately an issue in terms of the 2-year statute of limitations, then what would you have to say about what the majority in the Court of Appeals said about the fact that the act is to be liberally construed? And when you look at the fact that the plaintiff here said that she never really had her pain to subside since the May 2014 injury, coupled with the fact that her feet were deemed to have been giving her some problems relative to the back injury, why would we not look at jurisdiction in that type of way and therefore legitimize de novo review?
And again, we're saying that a true question of de novo review for jurisdictional questions concerns whether a party could be subject to the act at all. The reason you do that is to make sure the Industrial Commission doesn't impose the act on somebody who should never, ever be subject to the act under any circumstances. In this case, it just says that a right that a plaintiff has to assert a claim under the act, it's a right created by a statute. So they can't avail themselves to it until they file a claim, and the statute puts a 2-year time limit on that. It's just it's for an action of the plaintiff, not their standing.
If a claim has already been filed, even once upon a time, so to speak, and yet there is still the opportunity to relate back to it with a subsequent injury, as arguably has happened here, then why is the plaintiff here, under the facts of this case, still not availing herself of the operation of the act?
She never filed a claim for the 2014 claimed injury until May of 2017. So more beyond those 2 years. So she just missed the time, but that dealt with an action or an obligation imposed on the plaintiff by the act, not her standing as a person who might be subject to the act within the purview of the act. She could be in the purview of the act if she did what was required of her, which was to file the claim within 2 years. To your point about the evidence, there was also conflicting evidence that, she had 2 claims already in 2011 that she settled, which means if the injury is related to the 2011 claims, that's not part of it because she's already been compensated for those. And the commission found that she told the nurse when she went to the doctor that day on April 25th, 2017, this is from the time this is the same pain I've had since I've been on the 1300 row. She worked on the 1300 row in 2011. She did not work there in 2014. She was moved to a different place. So she herself initially related it back to those 2011 claims where she can't file anything else for that. They're resolved. She also later made a claim that there was a new injury in 2017. So there's a lot of options that the commission had here because she had alternate theories of why she should be compensated at that point. That called for the commission to make credibility judgments as to the plaintiff and the medical evidence, because even Dr. Jones, her expert, said he thought it was more likely the pain in 2017 was related to 2011 back claims. So that's how we would answer that, is there was competing evidence, and the evidence the commission found in favor of the plaintiff. So we again explained that we believe that the rule for jurisdictional review should be confined to cases that call for the court to consider whether the commission applied the act to a person who should be subject to the act, not questions arising under this statute or even 97-58. But 97-24 is the issue in this case, which is just deals with the actions and rights of the parties, just like anything else: accident, medical causation, disability. Otherwise, it disrupts the intent of the legislature and the intent of the act. And I will leave my.
I know you want to reserve 5 minutes. Can I take 1 minute to just ask you, assuming we are applying the any substantial evidence standard or any competent evidence standard, as I read the commission's order here, findings of fact 6 through 13 pretty much just recount the testimony. And then there is no finding of fact 14. And so we start with 15 where they say what the commission finds. And they find that her testimony that she was allegedly injured in 2017 conflicts with the prior testimony, but I really couldn't find a clear finding where they say that her seeking treatment in 2017 was related to her 2011 injury and not what happened to her in 2014.
I don't think they affirmatively found that. They made findings relevant to that, and they found that she did not show that that was for the 2014 injury. So this April 25th, 2017 treatment was not for 2014, and because based on the weight of the evidence that they found credible.
Most of their findings just recount what the testimony was, and there's conflicting testimony. And so we don't really know what they're crediting or not crediting. They just say that she didn't file, that the last treatment she got was April 2015, and she didn't file until May of 2017.
Right. And, this case was decided, it was two cases together that were consolidated. And when the plaintiff has not moved forward to appeal, but that doesn't mean that the 2017 facts should be ignored on appeal for purposes of looking at what the commission did, because the commission, there is also the option that her back hurt for something that had nothing to do with any of her workers' compensation, alleged workers' compensation injuries. There were the 2011, the 2014, and the 2017, or maybe something else, because she was treating for plantar fasciitis with her foot. So the commission doesn't have to find exactly what it was. It just found that she didn't prove that it was related to the 2014.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
Thank you, Your Honor. May it please the court, my name is Jay Gervasi. I'm here to argue on behalf of Doris Cunningham. This case comes before this court on a dissent, which for mandatory review here, mandatory appeal, that misapprehends what de novo review means. It seems like the argument is that de novo review applies to the jurisdictional matter, but when making the de novo review, the appellate courts are required to accept the facts found by the commission if they're supported by evidence, which is sort of not de novo review. That's the regular standard we apply to any kind of issue. Whether there are findings of fact and whether the evidence supports finding of fact and whether the findings of fact support the conclusions of law. In this case, the argument is pure and simple to change, to overturn decades of this court's precedent and call the filing deadline no longer a jurisdictional issue, so that the regular standard review applies to it. The Gore versus Myrtle Mueller case did not do that. It held that, and this court held that despite the fact that jurisdiction is that the filing deadline, timely filing, is a jurisdictional fact, that principles of estoppel can apply to it. I think somebody made reference to Larson's, and there's a broad range of there are states that say that it's not jurisdictional, and there are states that say that if it's jurisdictional, you can't apply estoppel. North Carolina is neither of those states. It is a jurisdictional issue, and de novo review applies. De novo is defined as allowing the appellate courts the authority to review the evidence and make different findings of fact from the ones that the Industrial Commission made. The only issue here is whether the Court of Appeals exceeded this authority. It did not. So this court should affirm the Court of Appeals decision. And that's really all I have to say. Thank you, Your Honor. If there are any questions?
Thank you, counsel.
Thank you.
Rebuttal.
Yes, and just to underscore, that there's not been decades of precedent from this court applying review to questions under 97-24 as calling for jurisdictional fact de novo review to determinations of whether a claim was filed within 2 years of the alleged date of injury or from the last payment of medical compensation. What the court explained in Gore was that this idea of this statute being jurisdictional was tied to the designation of a condition precedent. But this court has also said in Gore and in Hart that a condition precedent is different than subject matter jurisdiction. And that's why it just applied ordinary review, which was recognized by the Court of Appeals. That, one thing that plaintiff had argued in the brief at least was, well, that means that ordinary review applies to questions of whether the facts as to whether there's a estoppel that should be applied. But to everything else under 97-24, it's still just a jurisdictional question because that word has gotten used in the past related to condition precedent. And therefore there should be de novo review. So the argument is, when this statute was first interpreted by this court, it was deemed jurisdictional and ordinary review applied. And now it's advocating for a flip-flop. It's not jurisdictional, so you can have estoppel, but also that you should apply de novo jurisdictional fact review when it's never been applied by this court to those questions arising under this statute. And the question is why? Why is there a difference now that there wouldn't have been back then that wasn't applied in court? And there is not an answer, because the correct designation and what we'd ask this court to clarify regarding this statute is that jurisdictional fact review applies to questions about the commission's authority to apply the act to somebody. That's what defines the outer limits of its authority to decide and adjudicate questions. This statute deals with the plaintiff, an obligation on the plaintiff to do something, to avail herself of the commission's jurisdiction. And that's always been deemed distinguishable from a jurisdictional authority question, just like this court said in Hart, and just like was the basis of this court's decision in Gore. So therefore, we do ask that this court clarify, for the benefit of lower courts who have gotten it confused, that looking at the reasoning for why you assert that de novo review to jurisdictional facts just doesn't apply to the issues here. Otherwise, to hold otherwise is to reverse precedent in this court applying the standard of review to questions under 97-24, and also encourages upon the commission's prerogative to make findings of fact concerning the rights of the parties.
Thank you. Thank you, counsel. Thank you to both.
Thank you.
Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 45 minutes. God save the state and this honorable court.